One of my greatest pleasures here at Stanford, as someone who really loves teaching at Stanford, is my lifelong connection with my former students. There's literally not a week that goes by when I don't hear from, talk to, Zoom by, collaborate with, those are all the prepositions I was thinking of using, or see, a direct object, a former student. And I love when they return to campus, either to celebrate alumni reunions or just to stop by. So it's really a pleasure to see you all here today. Speaking of alumni, with the departure of Justice Breyer from the Supreme Court earlier this year, this is the first Supreme Court that lacks a Stanford alumnus for over 50 years. We've had 4 alumni on the Supreme Court in recent years, and now we have none. But that's hardly the biggest change at this Supreme Court. The current court is revisiting a number of longstanding issues, from substantive due process to religion to equal protection to the post-New Deal administrative state. And what I want to talk with you about today is sort of some of those changes. Now, this is a little bit of an odd format for me because when I teach at the law school, I never go more than about 3 or 4 minutes before I start cold calling on people. And this is not just a class without quizzes, this is a class without cold calls as well. Yeah, I know, people would really like that. But, you know, you there, and then pull out my cell phone because if you've ever seen The Paper Chase, you know, the professor there says, here's a dime, call your mother, you're never going to be a lawyer. And today I guess I would have to, here's my cell phone, you know, text your mom, you're going home now. How many of you in the room are not lawyers? Okay, good. See, because the first thing they always tell you about like oral arguments is know the people you're arguing in front of. And so this will help me because I don't want to give either too much or too little detail. I also want to apologize a little if I seem a bit disjointed, but on the flight back I was in New York for a legal meeting yesterday. And when we boarded our plane at JFK, we got everybody on the plane, they closed the doors, and then people started complaining about the smell, and it turned out that there was a cargo of fish 4 days ago that leaked into the baggage hold of the plane, and the pilot came out and said, I've just decided I'm not taking this bird anywhere. We're getting a new plane. And the new plane they were getting had just taken off from San Francisco. So I got here at 3:30 in the morning, so I'm not my usual lively self, but yeah. So I'm going to do a kind of who, what, when, where, why, and how. The where is obvious, Washington, D.C., First Street Northeast, and they are opening the building again for the first time since COVID so that you actually can go in and watch oral arguments at the Supreme Court. But one of the innovations during COVID that they had, which has a where everywhere, is they are now simulcasting the audio of Supreme Court arguments so you can actually listen to them live. And that's something they had never done before. They had done it, you know, for a couple of arguments that were very prominent arguments, but generally, if you didn't go, you had to wait a week. But now you can actually listen into the arguments, and it's quite fascinating, and you might enjoy that. So I'm going to start with the who at the Supreme Court. The current Supreme Court is the product of very interesting politics and structure of American politics over the last, say, 30-something years. Most of you, I think, unlike any of our current Stanford students, were alive on May 15th, 1969. Does anybody, I shouldn't even, I just promised I wasn't going to cold call on you, so I'm not going to cold call on you, but why did I ask you whether you were alive on May 15th, 1969? Does anybody want to take a kind of guess as to why? No, it was not Roe v. Wade. That was 1970, that was January 22nd, I think, 1973.
Clarence Thomas.
No, Clarence Thomas is 1991 or so. No, that was 1965 or 66. Yeah. No, we didn't have voting rights then. We don't have it now. No. Voting, not about voting rights. Yes, ma'am. No, that was even later. Yeah, over there. Map against Ohio, I think you're thinking of Map against Ohio, which was about applying the Fourth Amendment, which protects you against search and seizures to the states. That was 1961.
Nixon nominated Berger, which would have been to me the beginning of the decline of the Supreme Court.
You're the closest of anybody so far. May 15th, 1969 was the last time the Supreme Court had a majority of justices who were nominated by a president who was a Democrat. Since then, we've had a Supreme Court that is majority of the justices nominated by Republicans. Now, what's interesting about this is in the last 10 presidential elections, the Democratic candidate has won 5 times, and the Republican candidate has won 5 times. In those last 10 elections, because of the way the Electoral College works, the Democratic candidate has gotten more votes nationwide than the Republican candidate in 7, and the Republican candidate has gotten more votes in 3. But even though that's kind of how our politics has worked, Republican presidents have been able to successfully nominate 10 justices to the Supreme Court, and Democrats have only not been able to successfully nominate 5. And that ratio describes our current Supreme Court, which has 6 justices who were nominated by Republican presidents and 3 by Democrats. And this change in the Supreme Court has happened at a time when political scientists who measure these things tell us that American politics is the most partisan, and the partisan divide is the sharpest it's been since the late 19th century. There is now no real overlap in Congress or on the Supreme Court between the Democratic and Republican justices of the kind there used to be. So when I was clerking on the Supreme Court in 1985-86, some of the Republican nominees, most notably the man for whom I clerked, Justice Blackmun, were more liberal on a number of issues than the Democratic nominees, Byron White, for example. But that's no longer true. So the divide on the Supreme Court now is a sharp divide, and it maps onto a sharp divide in the country. Another observation about the Supreme Court, the who. Even as this is the most demographically diverse Supreme Court we've ever had, 4 women on the Supreme Court out of the 9 justices, 3 people of color on the Supreme Court out of the 9 justices, it's one of the least diverse courts ever in terms of experience. 8 of the 9 justices were Court of Appeals judges. 6 of the 9 justices clerked for the Supreme Court when they were young lawyers just coming out of law school. And I will say, as somebody who did that, I'm not sure that it's psychologically the best preparation for being a justice, because the kind of mystery of the Supreme Court, it gets into your blood in a way that maybe makes you a little too court-centric. And one of the other things about this Supreme Court is only 2 of the 9 justices have ever represented a criminal defendant. And a lot of the court's cases are criminal cases. And none of them has ever held elective office of any kind. The last justice on the Supreme Court to have held elective office was our own Sandra Day O'Connor, who had been the majority leader in the Arizona State Senate earlier in her career. And there's a famous line for those of you who've read The Best and the Brightest, the book by David Halberstam about how we ended up in Vietnam, in which Lyndon Johnson, as vice president, says to Sam Rayburn, you know, the people in this administration, when he's the vice president, the people in this administration, they're so brilliant. They've all gone to Harvard. They've been Rhodes Scholars and everything. And Sam Rayburn looked at him and said, I just wish one of these people had ever run for dog catcher anywhere. And this plays out powerfully in how the Supreme Court thinks about the other branches of government. Some of them have worked in the executive branch of the federal government as appointees, but none of them really has worked in the legislative branch. The last person with substantial legislative experience at the Supreme Court, although not as someone elected, was our own Stephen Breyer, who was the majority counsel to Ted Kennedy on the Judiciary Committee, and who was responsible also for writing a lot of the current antitrust laws. But this plays out in their dislike, indeed I think their contempt for Congress in a number of ways, and their distrust of the political process. So let me talk now a little bit about the how, which is how do the justices decide cases? What are the tools they use for deciding the cases? And there are, broadly speaking, 5 different interpretive methods that judges use to interpret either the Constitution or a statute that's in front of them. And this court has shifted dramatically in what it says it's doing with those methods from prior courts. The 5 methods, I thought I was going to have a whiteboard. I don't like using PowerPoints because I find that PowerPoint makes you a slave to your slides. And so if you see people are confused, but the slides are, there's no slide for, well, what about that? So I don't use those, but I'm going to just tell you the 5 methods, and then we'll go through them very briefly to give you a little bit of a sense of how the methods work. And if you want to read more about this, if you go to the American Constitution's website, there's a book that I co-wrote with our own Goodwin Liu, Stanford undergrad alum, now on the California Supreme Court, and Chris Schrader, who's now the Assistant Attorney General in charge of the Office of Legal Counsel. This is called Keeping Faith with the Constitution. It's a free download. I mean, you could get it from Amazon, but why pay? You know? Or as Barbara Babcock, who those of you who are from the law school remember, would say, why buy the cow? The 5 are textualism, originalism, structure and relationship, precedent, and pragmatism. Those are the 5 big methods. And let me just describe them all to you very briefly. Textualism says, read the words on the page and maybe look in a dictionary. But we have a written constitution. It's one of the real innovations of American government. You know, Britain has a constitution, but it's not written anywhere. We have a constitution that's written down. We have books and books of statutes. So read the language and just, you know, that'll tell you how to decide the case in front of you. And sometimes the words are relatively clear. You don't see many conflicts. You actually don't see a lot of litigation that gets to the Supreme Court when the words are absolutely clear, even if the justices sometimes pretend that the words are absolutely clear. Most of the cases they take are cases where there's disagreement among lower courts. So obviously not everybody thought the words were as clear as the majority of the Supreme Court does. And when they decide a case 5-4 and they say it's the plain text, you gotta wonder. But as I say, some of the words are relatively clear. So for example, many people would have loved to see the governor as the president of the United States, Arnold Schwarzenegger. But he couldn't be president because Article 2, Section 1 of the Constitution limits who can run to someone who's, quote, a natural-born citizen. So pretty clear he couldn't run. But even with the text, you need to put it in some kind of context. So, for example, Bill Clinton was born in Hope, Arkansas. So under the 14th Amendment, which says all persons born within the jurisdiction of the United States are citizens of the United States, he's a natural-born citizen. But he was born by cesarean section. Cesarean section.
C-section. Is that natural?
Right? Now, we know that's not what natural-born citizen means in the Constitution, but if you took English literature, you'll remember Macbeth, who was untimely ripped from his mother's womb, right? So if you're, or if you were looking at the insurance policies for how long a woman stays in the hospital after giving birth, there's different rules for natural childbirth and not. So you gotta know the context there, right? Or take the First Amendment to the Constitution. It says, Congress shall make no law. Well, it turns out it's not just Congress. It's any part of the federal government or any part of any state government shall make no law abridging freedom of speech, except no doesn't mean no. It means some. So for example, we have laws against securities fraud. Even if it's just, I say to you, buy this stock, it'll go up, I promise you, and I know it's going down, Congress makes that a crime. And when it says no law abridging freedom of speech, well, what does speech mean? It actually includes nude dancing, which is, I guess you speaking, you go, oh my God, but that's not what they mean by it, right? So we have all sorts of laws there. And sometimes there are words where there's sharp disagreement about what the word means in context. So as Mei Ling said, our clinic here at Stanford did a landmark case at the Supreme Court a couple of years ago that involved Title VII of the 1964 Civil Rights Act, which is one of the foundational statutes of what's often called the Second Reconstruction. It's the statute that says that you can't discriminate in public accommodations, so it responded to the sit-ins. It's the statute that says that no program that receives federal funds can discriminate on the basis of race, which is how the federal government effectively desegregated a lot of schools in the South. And we'll come back to Title VI at the end of the talk when I talk about where the court is going today. But one of the provisions of the act says that large employers in the United States, employers with more than 15 employees, which is a minority of the number of businesses in the country, but a majority of people work for those businesses, says that those businesses can't discriminate on the basis of race, sex, national origin, or religion. And our client in the case, a man named Mr. Zarda, the case is called Bostock because there were a bunch of cases that were all put together at the Supreme Court, was fired, he said, from his job as a skydiving instructor because he was gay. And so the question was, when in 1964, when Congress said you can't discriminate on the basis of sex, did that include saying you can't discriminate against someone for being gay or lesbian or bisexual, or in a companion case that involved someone at a funeral home, transgender? And the Supreme Court held 6-3 in our client's favor and said, this is because of sex, because you wouldn't have fired a woman who was attracted to a man. You can't fire a man who's attracted to a man because you're treating men and women differently. Now, the majority on the Supreme Court said, this is a plain text. Just read the dictionary. This is because of. But the court was divided 6-3 on this. And the question is, why were they divided 6-3 on this textual question? And in part, it's because of originalism, which is another way of reading a statute. And these ways kind of can glom over each other. That is, they can intersect and overlap a little. So originalism says, what did the people who wrote the language mean by it? And there are a variety of forms of originalism, but the big first question we should ask is, why should we care what the people who wrote the language thought about it? I mean, we don't all go around with little bands on our wrist, WWJMT, what would James Madison think? You know, there's a wonderful case at the Supreme Court that involved violent video games and the sale of violent video games to minors here in California. Minors, young people, not, you know, coal miners. The Supreme Court is going back and forth with at the oral argument, and one of the justices, Justice Scalia, asked a question about the understanding at the time of the framing of the Constitution of which kinds of speech could be restricted when you were dealing with children. And what Justice Alito leaned forward and said is, what he's asking is, what would James Madison have thought about violent video games? You know, grand theft, horse and buggy. So, you know, what would they think? Or there was another case that involved whether putting a GPS device, slapping a GPS device underneath a car so you could trace where the car went, was a search within the meaning of the Fourth Amendment. In the opinions that came out, Justice Alito made fun of this by saying it's like, you're asking, what would it have been like in 1790 to put a tiny constable on the back of every, you know. So one question is, why should we care? So, for example, the framers of the Eighth Amendment said that prohibited the use of cruel and unusual punishment. Should it matter how they would have defined cruel, or should we use what scientific knowledge we know today? So, for example, I don't know if any of you are from Philadelphia, but one of the famous old historical buildings in Philadelphia is the Eastern States Penitentiary. And the idea back then was the way that it was kind to deal with people who had committed crimes was you put them somewhere, and the word penitentiary comes from the idea you're going to repent. You would sit by yourself in a room, and you would think deep thoughts, and you would reform yourself. Well, one of the things we now know is that putting people in solitary confinement drives them crazy. They decompensate very quickly. So it wouldn't have been cruel in 1790. Indeed, that might have been thought to be the kind way of dealing with people. But today we might think that's cruel. So should courts look to more contemporary standards for figuring out what the words mean rather than asking what people thought back then? But even if we care about the framers' intentions, or what's now sometimes referred to as the original public meaning. What would people on the street have understood this to mean in 1789 if you're talking about the Bill of Rights, or in 1868, 1870 if you're talking about the Reconstruction Amendments? We confront what's often called the levels of generality problem, which comes in several kinds of flavors. We might ask whether they intended at the time, whether they understood at the time that these were words that were plastic and that would change over time as our understandings do. We might also ask what to do about things that they failed to anticipate entirely. So let me give you another example of this. Most of Congress's powers, huge part of their powers, come from Article 1, Section 8 of the Constitution, which lists like just a laundry list of powers, from the ability to create the District of Columbia to the right to have post offices and the like. And one of the powers there is the power to raise and support armies, to provide and maintain a navy, and to make rules for the government and regulation of the land and naval forces. Is the Air Force unconstitutional? I mean, they didn't know from things were going to fly, right? So, clearly the Air Force isn't unconstitutional. Why? Because we read those words today and we ask, well, what was the meaning behind them? It was military. So, President Trump's Space Force wouldn't be unconstitutional. Might be a bad idea, but not because it'd be unconstitutional. Air Force is not unconstitutional. And then we might ask whether they were talking about specific issues or they were trying to think more generally about general commitments. So for example, the Equal Protection Clause of the Constitution forbids state and local governments from denying any person within them the equal protection of the laws. So what does it mean to treat people equally? Well, we know, for example, that there's no state in the country that allows 12-year-olds to drive a car. So we're treating people differently on the basis of age. There are tons, virtually every law divides people into categories, those who benefit from the law and those who don't, those who are going to be criminally prosecuted and those who aren't. And yet, we can't have a country at all without these kinds of laws. So we might ask what that means, for example, for school desegregation or for race discrimination. We know that the same people who drafted the 14th Amendment segregated the galleries in Congress before which the amendment was debated. And we know that they segregated the schools in the District of Columbia, which were under their control. And yet the Supreme Court said in 1954 in Brown against Board of Education, you can't segregate schools on the basis of race. And they said, in that opinion, we can't turn the clock back to 1896, which was when the Supreme Court said separate but equal was okay, or to 1868, when the 14th Amendment was ratified, because today we know something about public education we didn't know then. And we know something about the psychology of people who are subjected to racial segregation that we didn't know then. So those words about equality mean something different now. So that's originalism. Many of the justices on the court today claim to be originalists, but none of them is a trained historian. They don't actually hear experts being cross-examined in front of them. They rely on what other people tell them about the history. And there's a great line of the late Judge Harold Levinthal's. He was talking about legislative history, which is when you look to try and figure out were there reports in Congress, what were the debates like, but it's the same thing for regular history, which he says the problem with judges doing this is it's like looking out over a crowd and picking out your friends. Because much of history is, for those of you who majored in history, you'll know this, much of history is hard to figure out. The documents are hard to read. Different people who have different interpretations feel vastly differently about it. So last year at the Supreme Court struck down New York's law banning people basically from concealed carry of guns outside their house. There was vast disagreement about what the rules were on carrying guns in public in a city in 1868, which is when the Second Amendment first became something that could be applied to the states, or in 1789. The Supreme Court decided an abortion case last year, Dobbs against Whole Women's Health. And in that case, Justice Alito, for the majority, said, The reason why we're not going to find that there's any right to abortion protected in the Constitution is at the time of the 14th Amendment, there was no right to abortion anywhere in the country. But there are a whole bunch of historians, for example, who say that there was no criminalization of abortion before quickening, which is usually at about 20 weeks. So which do you believe, right? Originalism doesn't get you there. You have to infuse it with something on top of that. So that's, talked about textualism, talked about originalism. Let me say a little bit about structure and relationship, which is, don't read the words of the Constitution in isolation. Don't even read the clauses of the Constitution in isolation. So don't read the First Amendment and then read the Second Amendment and think they don't have much to say to each other. Instead, ask what's the overall structure of the Constitution? What does that tell you about how to read different parts of it? And one way to think about that is to look at some of the broad principles that underlie our Constitution. One of the biggest ones is separation of powers. The idea that some things are for the states, some things are for the federal government. Some things are for the executive branch, some things are for the legislative branch, some things are for the judicial branch to understand. And try to figure out the answer to the case in front of you by asking, what does that broad principle say? There's another broad principle that's associated most famously with a former dean of the law school here, John Hart Ely, which is called the representation reinforcing principle. And what that says is the underlying purpose of the Constitution is to create a democracy, a self-governing democracy. And certainly if you look at all the amendments that have been enacted since the beginning of the Constitution, most of them are about political participation, and most of them broaden political participation. So women have the right to vote, no discrimination on the basis of race in voting, 18-year-olds get the right to vote, no poll taxes, people in DC get to vote for president, and so on. And so he says when you have a case in front of you, ask whether deciding it one way or the other will reinforce the democratic process, will make it easier for people to participate effectively or make it harder. So laws that entrench the people who are in power and make it harder for the voters to vote them out, those laws are unconstitutional. Now that doesn't necessarily tell you how to answer a particular case, because there are arguments, for example, sometimes on both sides about whether certain campaign finance laws increase competition or decrease competition. But at least you sort of get a sense from structure and relationship, well, this is how you ought to think about the issue. Well, let me turn to precedent now, which is the fourth of these. Precedent is the idea that there were smart people before us. It's a kind of humility point. There were smart people before us. They've thought about these issues. They decided the issues. We need a good reason to overturn that. And we especially need a good reason if people have organized their lives in one way or another around the previous understanding. So, you know, if you all of a sudden change the rules, lots of people will have invested lots of time and effort in various ways. This is a Supreme Court that is, I think, distinctive in modern American history in having a number of justices on it who just don't think precedent is very important at all, and who think, let's think these things over again from the ground up, and if I'm convinced that the right answer is A, the fact that lots of justices in the past have thought the right answer was not A, or was B, or was J, or was L, or was M, just doesn't matter to me very much at all. Because I've read the Constitution. Sometimes what they'll say is, I read the text, and everything, the precedent is just a gloss. I don't have to really pay any attention to it unless I'm persuaded by it. You saw last term at the Supreme Court one very important example of this, the Dobbs case, the abortion case, and you're going to see another example of this term at the Supreme Court in two cases, one involving Harvard University and the other involving the University of North Carolina, who take race into account in their admissions policies. Almost every major university in the country does. The places that don't are state universities in states like California that say that you can't as a matter of state law. But all of the Ivies, all of Stanford's peer institutions, with the exception probably of Caltech, take race into account in their admissions policies. It's never the dispositive factor, but it's a factor, just like, you know, can you play the violin? Do you want to be a doctor? Do you come from Missouri? You know, all of those kinds of things. And the Supreme Court has several times, since the Bakke case in 1976, and then in the Grutter case in 2003, and then in a series of cases involving a woman named Abigail Fisher, the Supreme Court has repeatedly reaffirmed the idea that both governments and universities that receive federal funds. Remember I told you about Title VI of the Civil Rights Act? That's why Harvard is covered. North Carolina is covered because it's a state university by the 14th Amendment. So the Supreme Court has reaffirmed repeatedly that you can take race into account as a factor in trying to achieve a diverse student body, because a university can decide that having a diverse student body is important to its mission. I think it's fair to say that everyone who's observing this expects the Supreme Court is going to hold that you can't, and they're going to declare that the court was wrong in Bakke, that the court was wrong in Grutter, that the court was wrong in Fisher 1, that the court was wrong in Fisher 2. So precedent. Now, universities obviously have relied on this in a whole lot of ways. And in last term's abortion case, Justice Alito, who wrote the opinion for the court, said, we can disregard the precedents that started with Roe in 1973 and then went to Planned Parenthood against Casey, and then a whole women's health case from a couple of years ago. We can disregard those because they were wrong from the get-go, because I don't see anything about the word abortion in the Constitution, although the word liberty is in the Constitution, the word abortion isn't. But of course the word family isn't in the Constitution either, nor is the word privacy. Piracy is in the Constitution, but not privacy. You don't have a right to piracy. So don't shiver me timbers. But what he said is, and there's no reason, there's no reliance interest here, because after all, you know, people are only pregnant for a relatively short period of time, so, but of course there is a reliance interest, which is women organize their lives in a whole bunch of ways around the idea that if they got pregnant and they decided that they couldn't carry the pregnancy to term, either because it was not the right time for them to have another child or because of severe fetal abnormalities or the like, they would have a backup to contraception and the like. But Justice Alito and a majority of the court said, well, that's not really a reliance interest at all. So precedent, that's the, and then the final one is pragmatism. There's a famous line of Justice Robert Jackson's, who was one of the best writers ever to be on the Supreme Court. And I will say on the current Supreme Court, there are great writers on both sides of the aisle. Chief Justice John Roberts is a terrifically good writer, and Justice Elena Kagan is a terrifically good writer. And they're both pleasures to read, even if you're not a lawyer. Pragmatism is, just as Justice Jackson famously said, the Constitution is not a suicide pact. So if it'd be a really stupid idea to do something, you can take this into account. And the person most identified with this over the last generation was our own Justice Stephen Breyer. He was famous for wanting to know, how does this work? Will it work? Is one of these things going to be easier to administer than another? So these are the different ways that courts can try to decide cases. And as I said, they tend to be overlapping. The current court claims to be both textualist and originalist, and sometimes you can't square those two things with each other. You know, a lot of times the question is whether, and this is one of the things we teach the students in the clinic, where we're teaching them how to write briefs that will persuade the Supreme Court, is there are two kinds of things going on there. There are reasons and there are justifications. The reasons are what motivates justices to decide the case in a particular way. Sometimes it's that the facts are really great. We had a wonderful case at the Supreme Court a couple of years ago that involved a gadfly. He's actually one of the few people I know who's been to the Supreme Court twice on two cases that had nothing to do with each other. His first case was about whether his floating home was a ship for purposes of admiralty law. The answer was no. And his second case was he got up at a city council meeting and said, I want to talk about corruption on the city council. And they said, you're not going to talk about that. He said, yes, I am. They had a policeman drag him out of the room, and he sued and claimed it violated his First Amendment rights. And we were up at the Supreme Court. I was arguing the case, and the justices had some very tough questions for me. Then the lawyer on the other side got up, and he was going on about how the law was all in his favor. And Justice Kagan said to him, you know, Ms. Karlan had some problems with some of the law, but you have some real problems with the facts. Because our client being dragged away from the microphone while wearing his suit saying, "But I have a First Amendment right," was videoed, right? And we know that the facts matter because the court decided that case in our favor, and then the next year took an almost identical case, but it involved a guy at the Alaskan equivalent of Burning Man. They have some like festival out there where they all get drunk and drive around in snowmobiles, and our client gave some lip to the police officer and was arrested, and they decided exactly the same legal issue the other way the next year because it just wasn't, our client just wasn't that sympathetic. So sometimes it's the reasons on the one hand, but when you read the opinions, they never say, we feel really sympathetic to Mr. Lozman, and then say, but we don't feel very sympathetic to the other guy. So the justifications are things like the text of the Constitution tells us this, or the original public meaning tells us this, or the structure of the separation of powers tells us how to decide this. But a lot of times the reasons and the motivations, the justifications and the reasons are not exactly the same. This court claims to be extraordinarily textualist and extraordinarily originalist. But it's less textualist than the famous Justice Hugo Black of the mid-20th century. He used to wave around, he carried around a copy of the Constitution in his pocket and he used to wave it around. And his view was he didn't even need to watch the dirty movies to decide if they were obscene or not, because the Constitution said Congress shall make no law. So he didn't go to, the justices used to go to the basement and watch the dirty movies to figure out, thumbs up, thumbs down. I mean, I'm using thumbs for obvious reasons here. But they would, they would decide by watching the movies. And there's a famous story of towards the end of his career on the Supreme Court, Justice John Marshall Harlan was nearly blind, and so Justice Marshall would sit next to him and narrate the movie. But Justice Hugo Black, he did not go down to see the movies because he said he didn't need to see the movies. The words no law meant no law. Right? There's nobody on the Supreme Court who's that textualist. And as for originalism, as I said, you can make a lot of different arguments from history. That's why we have history departments, because there are lots of different ways of reading the history. So that's where the court claims to be. And now I'll just say a couple of minutes, because I want to save 20 minutes for questions, about the what that I haven't already said, which is what's different about this Supreme Court in a way. And I want to point to a couple things that I think people who aren't court watchers sometimes don't think about. And one of these is it changes the court's agenda in a pretty dramatic way. Because the way the Supreme Court decides what cases to take or not is something that's called the rule of four. It's not in the Constitution, it's not in any statute, it's not actually written down anywhere. The only reason we know there's a rule of four is in 1925, Chief Justice Taft testified that they had a rule of four, and since then they've kind of kept to it, but they could change it tomorrow. And what that rule says is, with very few exceptions, maybe one or two cases in an average year, the Supreme Court has to have 4 justices who want to hear an issue before they will schedule the case for oral argument. And now, with a 6-3 divided court, there are a lot of issues that are not even going to get onto the agenda. And we saw that in the first orders list that came out this year at the Supreme Court. There was a case that involved staggering race discrimination. It's a case, a guy was convicted of murdering his wife. He was black, she was white. Several of the jurors said they disapproved of interracial marriage, and yet they were allowed to sit on the case. And 3 justices said, we really ought to hear this case. But they couldn't get a 4th, right? So, this guy's just out of luck. So that's one thing. The second big thing is there really isn't a swing justice on the current Supreme Court. Until the death, over the course of my career, the swing justices have moved steadily to the right. So when I first started litigating cases at the Supreme Court, working on cases, Justice Powell was the swing vote. Then it was Justice O'Connor. Then it was Justice Kennedy. And then it wasn't exactly clear who it might be, but some people thought the Chief Justice might be a swing on some issues. Justice Gorsuch might be a swing on others. But now there really isn't a swing justice on the Supreme Court. And that is going to change things dramatically as well. The Supreme Court has pulled out of a number of areas of law that it had been quite active in, most notably policing the political process, at the very same time that the political process is under a lot of strain. But it may step back in this year with a constitutional provision that no one had really thought had very much to say, which is the so-called independent state legislature doctrine. And you saw a little bit of this in the 2020 election, which is Article 2, Section 1 of the Constitution says that the states should appoint their electors in the Electoral College in the manner that the legislature shall direct. And the question is, what does the word legislature mean? Does it mean the legislature can do whatever it wants, or is the legislature constrained by the state constitution and by what state judges think? And we're going to see that play out this year. There's going to be arguments about textualism. There's going to be arguments about originalism. And it'll be really interesting to see where the Supreme Court ends up with that. As I've said, they already also have cases on the docket about affirmative action. They're going to have important cases about administrative law, and the current Supreme Court seems very hostile to administrative agencies. You saw this during COVID when they said that OSHA couldn't require vaccinations of people who worked for large employers, because even though OSHA is entitled to regulate occupational health, people who got the vaccine were healthy on the job and off. And so it wasn't really about regulating the workplace. It was about regulating society in general, and the text of the statute that gave OSHA the power wasn't clear enough then. So lots of different issues at the Supreme Court, a very different Supreme Court. So thank you all very much, and have a great weekend.